Hello, and welcome to the Washington Monthly. I'm your host, Ann Kim.
And I'm your co-host, Garrett Epps.
In this episode, how a pending Supreme Court decision could gut the Voting Rights Act and turbocharge gerrymandering even more.
I think the problem has become supercharged in these cases involving race. Because not only did the U.S. Supreme Court say we're not going to police partisan gerrymandering, but now we're seeing states use politics as their defense to every other potential claim against their maps.
Garrett speaks with voting rights expert Josh Douglas, a law professor at the University of Kentucky School of Law and a contributing writer to the Washington Monthly.
Josh, welcome to the podcast, and thank you very much for making time for us. You are, as our readers know, you are our go-to guy and sort of guru in these volatile voting questions. And we also love talking to you because you're the democracy optimist, as you have described yourself, and a little optimism lightens the whole day. But I'm not sure you were optimistic about the current case. You wrote a piece for the monthly called How the Roberts Court Could Neuter the Voting Rights Act. It's discussing this case called Louisiana versus Calais. Could you tell us a little bit about that?
Yeah. And first, it's always great to be joining you for conversation. So thanks for having me. And, it's funny that I self-branded. And so I guess people refer to me as a democracy optimist. And I like to point out that being a democracy optimist doesn't mean that I think everything's great. It means that I think there's hope for the future. And, if we didn't have hope, then we would only have despair. And that doesn't really help anybody. So
that's right.
I'm not particularly optimistic about this case that we're going to discuss, but I think of democracy as in the long term and think about what can we do to help sustain democracy, even given the troubled and turbulent times that we're living through right now.
You wrote some very interesting stuff some years ago about how you got involved in the voter ID questions down in your state and actually helped to make this proposal much less punitive than it might have been. And I think that was sort of part of the monthly is like, let's find ways we can make it better. And people still talk about that piece.
Yeah, absolutely. And it's great to know that that's had an impact and that, again, there are ways to get little wins in spite of what might seem like the constant deluge of negative stories. But let's talk about Louisiana versus Calais, because I do think this could be the potential for a not great outcome at the U.S. Supreme Court in terms of the future of minority voting rights. So this is the second iteration of this case reaching the U.S. Supreme Court or reaching the second argument in this particular case, but it's actually the second lawsuit with respect to Louisiana's redistricting. So Louisiana has 6 congressional districts, and it's got a population that's about 33% Black individuals, so about 1/3 minority. And when Louisiana redrew its congressional lines, like every state has to comply with the one person, one vote standard, or that each district has roughly the same number of people, when it did so, it drew the lines such that only one of the 6 districts would be majority Black. So in the language of the lawsuits and the law, only one district out of the 6 would give minority individuals an opportunity to elect a candidate of their choice. So there was a lawsuit filed by some Black plaintiffs under the Voting Rights Act, Section 2, which prohibits any voting rule that has the effect of discrimination. And the lawsuit said, you drew this map, Louisiana drew this map, it has only one of 6 Black majority districts. It's got a population that is 33% Black individuals. You'd think that maybe you'd want to have closer to 2 districts where Black individuals could elect a candidate of their choice, or at least have some sort of influence. And the lower courts agreed. The lower court said, yes, this dilutes minority voting strength. The U.S. Supreme Court put that decision on hold, and so Louisiana actually used the map with only one of 6 for the 2022 elections. But then eventually the courts essentially agreed and said that the map that had only one of 6 Black opportunity districts was a violation of the Voting Rights Act, Section 2. So Louisiana went and drew a new map, and it drew 2 of the 6 districts being majority Black, It also did some kind of funny line drawing to try to protect some of the incumbents, Mike Johnson, Speaker of the House in particular. But they passed a new map that was fairer in terms of minority representation, in that there was 2 districts that were understood to be majority minority or majority black. So then some white plaintiffs sued, and that's the case that we're talking about now, the Calais case. Some white plaintiffs sued and said, hold up, Louisiana, when you drew this new map that has 2 of 6 majority black districts, you thought about race too much. So separate from the Voting Rights Act, Section 2, there's another line of cases under the Equal Protection Clause of the 14th Amendment that basically says you can't think about race too much, that race can't be the predominant overriding concern. And so the challenge here is that Louisiana thought about race too much in drawing the map. And if Louisiana comes back and says, well, we had to think about race to ensure that we were complying with Section 2 of the Voting Rights Act, well, the plaintiffs say that makes the Voting Rights Act itself unconstitutional. So this is a long windup to say that this case could stand for a very important proposition about the constitutionality of Section 2 of the Voting Rights Act. Because if the court finds that the reason the state drew the map the way it did with 2 of 6 majority black districts was to comply with the Voting Rights Act, and that is in and of itself thinking about race too much, then the court could say that the Voting Rights Act itself is unconstitutional.
Just so our listeners catch up, we have this, the effects test under Section 2. And what that means is it doesn't have to be intentional discrimination. Is that a fair statement?
Right. And so there's 2 ways to think about discrimination. There's the intent, right? I want to discriminate against people. I, decide to draw the lines purposefully in a way that will make it harder for black individuals to elect a candidate of their choice. That would be, the smoking gun intent. Hey, let's draw the lines this way to harm minority individuals. But Congress in 1982, responding to a previous Supreme Court decision, a case from 1980 called City of Mobile versus Bolden, Congress updated the Voting Rights Act and said, no, we meant effects. So the court in that City of Mobile case construed the prior version of Section 2 to only reach intentional discrimination. And Congress immediately took that decision and said, no, what we want is Section 2 to reach effects. So we take one law, we pass one law. We're not trying to discriminate against anybody, but it just so happens that the effect of the law is discrimination. And maybe one way to sort of think about this in a more concrete manner outside of redistricting is a voter ID law. So when states pass a photo identification requirement for voting, they're not intentionally discriminating. Usually, at least, they're not trying to intentionally discriminate against minority individuals. But we know, just based on living conditions, structural inequalities, the economy, that black individuals are less likely to have an ID that counts, an ID that qualifies. So you might say that in some states, depending on the nature of the photo ID law, a photo ID requirement might have the effect of discrimination on the basis of race, even if the state legislature was not trying or even thinking about race in doing so. And so that's what the lawsuit was about. The initial Louisiana map that had only 1 of 6 majority black districts was that even if you weren't trying to make it harder for black people to elect a candidate of their choice, the effect of the map did that and therefore violated Section 2.
And the candidate of their choice thing is important because people sometimes hear these discussions as you're entitled to majority black districts or majority Latino districts. And that's not exactly right. It's something called opportunity districts, if I recall correctly. Could you talk a little bit about that?
Yeah, we say candidate of choice because we don't mean that black people get to vote for black candidates or that we measure a map as to whether it has the effect of discrimination by looking at the population of the area and then compared to the percentage of black individuals who are elected if we're talking about black people for minority. This also applies for Latino or any other sort of a racial minority. But, good way to think about this is, who was the presidential candidate of choice among the Democratic nominees for president in 2020? Who was the candidate of choice for many Southern black Democrats? It was Joe Biden. a white individual, right? So it so happened that Joe Biden had policies and had a message that really called to a majority of Black individuals, particularly in places like South Carolina. And so we're not talking about redistricting there, but that is a good example of a white candidate who was the candidate of choice for Black individuals in those places.
And note in that case, there was, for at least part of that cycle, an actual African-American candidate, and Biden was still drawing the support you mentioned.
Yeah, exactly. Right. So it doesn't mean that and again, the way to think about this is you don't care how many minority individuals are in the legislature. You care whether those individuals in the legislature were elected by the minority. In the more minority people, did they have the opportunity to choose someone that collectively they supported? Now, it's often going to be someone of the same race, right? If you just look at the numbers, it's often going to be someone of the same race, but that's not the test. And that's not what the consideration is.
You listened to the oral argument. I did too. I have a feeling a lot of it went over my head that didn't go over yours. What was your feeling about the oral argument in that case?
So the concern I have, I think it seems pretty clear that there's going to be 5 votes to cut back on the Voting Rights Act Section 2 in some way. And, the state is saying, or at least was saying, the state kind of has come down now in favor of striking down or limiting Section 2. But previously, the state was saying, we're kind of between a rock and a hard place. We have to think about race some to ensure that we're not violating Section 2, that we're not passing a map that is discriminatory on the basis of race. But we can't think about race too much because that would run afoul of the Equal Protection Clause cases, this whole line of case law, sometimes referred to as the Shaw line of cases after the first case in this series. That case was from North Carolina in 1992. So you can see how long we've been talking about these issues as well. So Louisiana is saying in some ways, look, we're between a rock and a hard place. We have to think about race some, but not too much. So just get us out of this quagmire. Well, one way to do that would be to say that if you're thinking about race to comply with the Voting Rights Act, then that's okay, essentially. And for the lawyers out there, I'm thinking about strict scrutiny review, that highest level of judicial review where the state has to demonstrate a compelling interest for doing something like making distinctions on the basis of race. The court would say, well, compliance with the Voting Rights Act Section 2 is a compelling interest. That's where I think the court should go to preserve both of these kinds of considerations, right? That Section 2 of the Voting Rights Act is really important. But after the oral argument, I'm very concerned about a suggestion made by the U.S. Solicitor General and where I sort of think this is probably going to go. Now, the court is probably going to want to avoid the headline of U.S. Supreme Court strikes down Voting Rights Act. So at least, the Chief Justice Roberts type among them might want to do something that looks more mild, even though he has a long history of advocating against the Voting Rights Act. And what the Solicitor General argued essentially was that if the state can say that it's trying to achieve a political end and not just a racial end, then the map is valid. That is to say, under a Section 2 lawsuit, a valid defense would be politics, not race. Now, the court already adopted this basic standard in the constitutional racial gerrymandering doctrine, where in that Shaw line of cases, in a case out of South Carolina from just a year or two ago, Alexander versus South Carolina NAACP, the court basically said that if Black people challenge a map because the state thought about race too much in drawing the lines, Black plaintiffs are saying this is unconstitutional, the state can justify it by pointing to politics. We were trying to achieve a particular political end. We were trying to protect certain incumbents. The U.S. Solicitor General basically suggested to incorporate the same kind of idea into the Voting Rights Act Section 2 as a valid defense. And my suspicion is that's somewhere where we'll end up on this question.
Well, that leads us into this whole issue of partisan gerrymandering and the, to me, weird turn that the court has taken on that. But in a case called Rucho versus Common Cause, they basically said, if all you're trying to do is rig the system so that your candidates win, that's okay. That's partisan gerrymandering. if you're trying to rig it so race is not dominant, well, that's a different thing. But we've now got this thing, and I think, as you say in your piece, that is kind of a novel idea that partisan discrimination, trying to set up the system so that one party always wins, that's okay. In fact, that almost even from the tone of the oral argument, sort of praiseworthy. That's a thing that's why we have legislators. So could you talk a little bit about that and about the change? Where did this idea come from and how has it developed?
Yeah. And, in that Rucho case in 2019 out of North Carolina, the court said there's something that they referred to as constitutional partisan gerrymandering, which I've always thought that phrase is very strange. The whole question is, why should partisan gerrymandering, where the politicians in charge draw the maps to help keep themselves in charge, to help them win re-election, how could that be constitutional under an understanding of the Constitution that protects equality, that protects democracy, and democracy being derived from the consent of the governed, from the people? So partisan gerrymandering had been challenged for years, and that several times when the U.S. Supreme Court had faced the issue, the court basically had said, well, partisan gerrymandering, or at least some level of partisan gerrymandering, is unconstitutional, but we haven't figured out how we tell the difference between something that's perfectly fine and legal and something that goes too far. Because what the court said is, anytime a legislature does anything, that's inherently partisan, right? And we kind of expect that. We expect when the legislature passes tax laws that it's going to be partisan in nature. And if you don't like the laws that the legislature passed, well, the solution is to vote the bums out. And so the court has struggled with this idea of, if everything a legislature does is partisan, and the U.S. Constitution gives state legislatures the authority to dictate the times, place, and manner of federal elections, so it gives state legislatures the authority to draw the maps, how do we tell when that action is their normal politics or is politics gone too far? And the court had said, we don't have a test that we like. Well, a bunch of different scholars, law professors, political scientists, mathematicians, have all come up with tests to measure when a map is sort of among the normal range of what you might expect, even from a partisan body, and something that's a far, far outlier. And the North Carolina map, for example, was clearly a far, far outlier, and the map drawers didn't hide what they were doing. So in North Carolina, there was 14 congressional districts, and they drew a map that was 10-4. So 10 strong Republican districts and 4 Democratic districts. And when asked why, and the key Republican lawmaker who drew the map, when asked, why did you draw a map that was 10-4? He said, well, I couldn't figure out a way to make it 11-3 and still comply with the one person, one vote standard, right? So it was explicitly partisan in terms of what they were doing. And the U.S. Supreme Court basically said, that's fine. That we're not satisfied that there's any test that can tell us the difference between normal politics in what a state legislature does and politics that have gone too far. There's many problems with this. And the first being, this is letting the politicians choose their voters instead of the other way around. This is the foxes guarding the hen house, because what's the one area where maybe we should trust state legislatures the least? It's about rules that help them stay in power, or rules about their reelection, right? State legislators, their number one goal, you'd wish it were to serve the people well, but their number one goal is basically to win reelection and keep their job. And so what better way to do that than to draw the lines in such a way that it basically makes it impossible for the other side to win, especially when you have, the primaries becomes the only game in town, essentially. So in most districts in the country now, we know which side's going to win, Democrat or Republican. There are very few swing districts these days. Okay, so that's problematic in and of itself. But I think the problem has become supercharged in these cases involving race. Because not only did the U.S. Supreme Court say we're not going to police partisan gerrymandering, but now we're seeing states use politics as their defense to every other potential claim against their maps. And we're seeing the Supreme Court essentially still defer to the legislature when using politics as the defense. So that Alexander case from South Carolina, the argument was that the state drew the map to pack as many black voters in as few districts as possible, such they had a super majority in very few districts and white people could control the rest of the state, basically. And that was the claim. And so the claim was you thought about race too much. And the state was able to say, well, we also thought about politics, and there's a political reason for why we did this. And the U.S. Supreme Court basically said, okay, that defeats the plaintiff's claim. And I fear that's the similar type of standard is going to be set out in this Louisiana versus Calais case. So it's really the intertwining of the partisan gerrymandering cases with the consideration of race and the allowance of states using partisanship as that defense.
Yeah, if I can push on that a little bit as a con law, guy who thinks in the sky, the striking thing to me, tell me if this is right, is that you start off with a thing where they're saying complying with the Voting Rights Act is a compelling interest. And then they say, the court says, well, yes, but you're not forbidden. You're not forbidden to use partisan politics. But gradually it's now become something that's equal to the non-discrimination claim, that it's like,
It's not even equal anymore.
Yeah.
I would say that the partisan defense has subsumed the concern about equal representation because the plaintiffs bring a claim, and if this is how Louisiana versus Calais goes, plaintiffs bring a claim saying, here's the map that you enacted, here's the percentage of minority individuals, here's why the map was drawn. And by the way, when making out a Section 2 claim, it's not enough for the plaintiff to simply say only one of the 6 districts is majority black, and it should be 2 because we're 33% of the population. The plaintiffs have a much higher evidentiary burden than simply looking at the numbers. They have to propose a new map to demonstrate how minority individuals live geographically near each other, such that you could draw a new map that had more majority black districts. You also have to demonstrate that the minority individuals in your area tend to vote as a block, tend to vote in the same way, have the same interests. You also have to show that the white majority tends to also vote as a block to outweigh the minority. So there was a district in North Carolina that was challenged, and the court said, well, but white people are crossing over and voting for the black preferred candidate. So you can't make out a claim there. And then after you do all of that, you still have to demonstrate under, quote, the totality of the circumstances that minority individuals are worse off in the area, looking at geographic living patterns, looking at history of discrimination, the ways they're excluded. So you've got a pretty high evidentiary burden for the plaintiffs to do that. But even if the plaintiffs clear all of those hurdles, if the court adopts this test that partisanship can insulate it, then all of that would be negated by the state simply saying, we were seeking to achieve a partisan end, here's what it was. And at least in the racial gerrymandering constitutional claim, that defeats the argument that race is used too much, at least when it's the black people challenging the white majority legislature in terms of drawing the map that way, as in South Carolina. And that could insulate Section 2 challenges as well. So, the headline would be court guts Section 2 or cuts back on it, but not strike it down. But the practical effect would be that it would be extremely difficult to bring a Section 2 claim against a map if the state could justify it based on its partisanship and partisan arguments.
Well, one of the enigmas in this whole thing to me, and I know you know this, is the through line of Chief Justice John Roberts' career. I covered the court for 10 years, and Roberts remains an enigma to me, what he's thinking. But we know that among the very first things he did when he came to Washington to work as counsel to William French Smith in the Justice Department was produce memos arguing strongly against the current Section 2, that he said the effects test is, I don't know what he said it was, that he was against it. And he seems to have really had it in for the Voting Rights Act, over the next 45 years. Do you have any sense of what the idea behind this is? Is there any?
Well, I will not be surprised if Roberts is the one that writes the opinion adopting some kind of test that really waters down Section 2. I think that would be consistent with his viewpoint over the years against the Voting Rights Act. Of course, he wrote the Shelby County decision that gutted Section 5 of the Voting Rights Act in 2013. But I think as an institutionalist who cares about the court and people's perception of the court, he would want to avoid that headline of court strikes down the Voting Rights Act. And so that's why I think that in particular, he's going to be the one that tries to do this through death by 1,000 cuts, as opposed to, what I suspect Justice Thomas would want, which is just strike it down. I mean, he has said explicitly multiple times how to strike down Section 2 of the Voting Rights Act or different aspects of the Voting Rights Act. So we don't really have to speculate too much on Thomas's views here. So I think that, it's always hard to read the tea leaves and to predict what actually is going to happen, but a ruling that seems more incremental because it doesn't throw out the entire law would be consistent with what Roberts has done in the past and also consistent with his views of the Voting Rights Act over the years.
Well, with Roberts, and you mentioned the Shelby County decision, which basically did away with the pre-clearance mechanism. And he did it on the grounds, or his argument basically in that opinion was, why, look, he sounded to me like a lot of the older white Southerners I grew up among, who about 1965 began saying, "Well, look how far we've come. We don't need any more change. We've done these various things." And he said, so much has changed since the Voting Rights Act was enacted. And to me, and this may just be my Saturnine temperament, but I keep looking around and saying, how much hasn't changed? As you look at what Louisiana did or South Carolina did, how far have we come from that period when the Voting Rights Act was needed to hold back legislators who were going to explicitly discriminate? Have we come far at all? Are we headed all the way back?
Well, I think this is where my optimism, my democracy optimist viewpoint will come in a little bit, which is to say that we're definitely way, way better off in terms of equality in voting opportunities, equality in voter in representation since the early 1960s. And I think that's kind of undeniable, right? We don't have explicit literacy tests anymore. Registration rates between minority individuals and white individuals has come a lot closer. It's not exactly on par, but the registration gap is not as big. The turnout gap is not as big. It still exists, but it's not as big. So I think we can say that we have come a long way, but that doesn't mean we're done, right? And so just saying there's been progress doesn't mean that progress is finished. You think about the famous Martin Luther King Jr. quote, "Arc of the moral, the universe is long, but it bends towards justice." That long-term goal, bending towards justice, I think is what we see. And so if the Voting Rights Act gets cut in these ways, or the effectiveness is tempered, yes, that's going to set us back in terms of equality in representation, not to the pre-1965 years, but it's going to be another hurdle to then overcome. So, I think the progress in voting rights is really a story of fits and starts. And, we might be having a minor retrenchment, but my democracy optimist mind sees that longer history and sees that, okay, we need to find different tactics or new ways to tackle the problem of what Justice Ginsburg referred to in her dissent in Shelby County as the second generation barriers to voting. I think we've cleared and fixed many of the first generation barriers, the explicit attempts to defeat minority voter opportunity and representation. But that doesn't mean we're done because we haven't handled the second generation barriers like voter dilution and the way the lines are drawn.
Well, on that note, the note of democracy optimism, which, I need to talk to you every now and then, keeps me going. I think we'll wrap it up here, but I do want to warn you that there's going to be a lot of voting stuff coming down, and I'm going to be bugging you to write more for the Washington Monthly. Unfortunately, you're our go-to guy. So thanks so much for taking the time to talk to us.
Yeah, thanks for having me.
That's it for this week from the Washington Monthly. I'm Ann Kim, and on behalf of my co-host, Garrett Epps, thank you for listening. If you like what you heard, don't forget to subscribe to our channel or wherever you get your podcasts. Have a wonderful week.